Fusion Mobile, quality e-learning experience on the go.
Law of contract. A contract can be defined as an agreement between two or more parties which is intended by them to have legal backing. A contract can be classified into formal and informal contract. And under formal contract, we have the contract of deed or specialty contract and contract of record. Contract of deed or specialty contracts are promises written on paper, signed, sealed, and delivered. A contract under seal is carried out by putting a seal on it. They do not usually require consideration, for example, conveyance of a legal estate. Contract of records. These are obligations imposed by the court. They are not true contracts, but contracts which are acknowledged before a law court. An informal contract. Informal contracts are simple contracts which must possess all the essential characteristics of a valid contract. All contracts that do not belong to the formal contract mentioned earlier are referred to as informal contracts. And because of its flexibility, it may be difficult to execute. For example, the contract of sales. Essential characteristics of contracts include 1. Offer and unqualified acceptance, intention to create legal relations, there must be valuable consideration, genuineness of consent, legality of object of the contract, parties must have contractual capacity, certainty of terms of contract, possibility of performance, formality of a contract. Offer an unqualified acceptance. In a valid contract, a definite offer must be made by one party to the other, and the offer must be unconditionally accepted. Acceptance must be absolute, and once it is completed, it cannot be revoked. Advertising and invitation to tender, for instance, are not offers. An offer can be terminated in the following ways: through revocation, lapse of offer, a refusal or counter offer, and also when the offeree notifies the offeror that he does not wish to accept the offer. Intention to create legal relations. The terms of an agreement must state clearly that the parties intended to create legally binding contracts. There must be no clause that will exclude the court. Another characteristic is that there must be a valuable consideration. A consideration must move from the promise. It must not be past. A consideration must not be vague or indefinite. It must be legal. Consideration must be real but may not be adequate. Genuineness of consent. Here, the consent of the parties involved in a contractual agreement must be genuine. Agreement of the parties to a contract must not be obtained under duress, undue influence, misrepresentation, or mistake. When a party has entered into a contract as a result of mistake, the contract can be voided if it is one of the facts and not of law, or the mistake is so fundamental as to negate the agreement. A mistake can be operative or inoperative. Legality of objects to the contract. The contract must be undertaken for legal purposes. The parties must have contractual capacity. A company cannot enter into a contract outside its memorandum of association. Possibility of performance. The parties to a contract can enter into a contract once they are sure that they can do the job. it must be possible to carry out the contract. Formality of a contract. Contracts can be made in any form, namely written, oral, or implied by conduct, but in exceptional cases, the law lays down a particular requirement. We have different types of contracts. The voidable contract. This is a contract which is valid unless and until the party entitled to void it actually does so. It is a binding contract but may be rejected by the third party. The valid contract. This is an agreement in which the parties are legally bound to carry out their obligation. It is binding and enforceable by the law. The void contract. This is one which is destitute of legal effect. It is no contract at all. The parties are not under obligations to each other. The unenforceable contract is one which, although valid, cannot be enforced in the court because of the absence of some written evidence or because the time stipulated for bringing action has elapsed. The illegal contract is not only a void contract, but any other contract related to it will also be void if the main contract was strictly illegal. The executed contracts are contracts that have been completed. In this contract, the duties and obligations of the parties have been carried out and nothing remains to be done. The executory contracts are contracts in the process of being executed. The contract has not been totally carried out. The parties still have obligations to carry out, as some things still need to be done before it is totally completed. Severable contract. This is a contract that can be divided into several parts. Payment for parts that have been completed can be claimed. Whether a contract is severable or not depends on the intention of the parties. The quasi-contract. The quasi-contract is said to exist in those exceptional circumstances where a court feels compelled to impose obligation upon one person even though the person has no intention of making a contract. For example, a doctor who rendered first aid treatment to an unconscious man and later sent a bill for his services. The court in this case pretends there is a contract. The oral contract. These are contracts entered into through the use of verbal communication or spoken words. They are not documented or written down. Oral contracts are also as effective as written contracts. We also have the written contracts. Written contracts are those contracts which are documented. The duties and obligations of the parties as well as terms of agreement are clearly stated so as to establish clear-cut evidence in case of default. The expressed contract. Expressed contracts are contracts in which the parties have expressed their duties or obligations and terms of agreement orally or through written form. The implied contracts are those contracts which are entered into through the acts and conducts of the parties. The terms of agreement are not shown by oral or written declaration. For example, a person who is getting his hair cut in a barber shop actually desires the services and is willing to pay for it. The bilateral contract. In this type of contract, the promise to do something is given in exchange for another. Promise will flow in two directions, and the parties involved must, as a matter of necessity, carry out their promises. For example, when a manufacturer enters into a contract in May with a supplier, calling for the supplier to deliver 10,000 books by September. In that regard, each party has promised the other to perform one or more acts at a subsequent time. Such contract consists of a promise in exchange for another. The unilateral contract. This is a contract where the offer consists of a promise to pay money in return for the performance of an act. Promise is not given in exchange for another. That is, it flows in one direction. For example, Mr. Ojo promised to compensate whoever finds his stolen television set if it is found and returned. Termination of contract. A contract can be discharged or brought to an end in the following ways: by performance, by breach, by agreement of the parties, by frustration, by lapse of time, death or insanity of the party, by bankruptcy, by illegality of the object. A contract can be discharged when one of the parties fails to perform his own part of the contract. This is called breach of contract. A contract can come to an end when both parties agree to release each other from contractual obligations. It can be bilateral or unilateral. A contract terminated by frustration is a contract discharged when the subject matter or basis of the contract has been destroyed or frustration by an act of God, for example, flood, war, etc. A contract can be brought to an end when the period fixed for the agreement comes to an end. The death or insanity of one of the parties will automatically bring a contract to an end. A contract can be brought to an end when either of the party is bankrupt. If the subject matter is illegal, for example, prostitution, the contract can be terminated. Some terminologies used in contracts includes the counter offer. The counter offer refers to an offer which is made after the original offer. We also have the tender. A tender is an estimate submitted in response to a prior request. It does not amount to an offer. We also have party. This refers to each person or group of persons in a contract. Conveyance. A conveyance is the document which transfers the title of unregistered land. Quasi-contract. Quasi-contract occurs when the law imposes obligations of a contractual nature even when no true agreement exists between the party. The quantum merit. The quantum merit simply means as much as you deserve. The offeror. This is the person that makes an offer. The offeree. This is the person to whom the offer is made and he accepts the offer. The privity of contract. This is the relationship that exists between parties to a contract. They can bring an action on it. The ex post facto warranties. This refers to conditions of a contract turned into warranties. Auction. In auction sales, bids are made by prospective buyers and the commodity would be sold to the person making the highest bid. Ultra vires. Under this doctrine, a statutory or registered corporation can only give contracts readily within the powers conferred upon it by the statute governing it and the memorandum of association. We also have the promisor. This is the person who makes a promise in a contract, while the promisee is a person to whom the promise is made. The guarantor. This is a third party who assures one party to a contract of the other party's compliance. Damages. This is compensation awarded by a court of law to a plaintiff who has suffered loss as a result of an act of the defendant. Some remedies for breach of contract includes damages, action for an agreed sum, quantum merit, injunction, rescission. Quantum merit. Under this remedy, the plaintiff will be awarded as much as is earned. Injunction. This is a discretionary court order which may be prohibitory or mandatory. Rescission. In granting rescission, the court must be satisfied that it is possible to restore the parties to their pre-contractual positions. The injured party has a right to sue and claim damages. The innocent party may sue for an agreed sum.